Hello. This is Alyssa's fault. We got some weird formatting.
All right. And Mr. Arthur, can you hear me?
Yes, Your Honor.
I've not seen it.
All right, Mr. Arthur, we're here right now. We're going to do one step at a time, okay? So right now we're here on the motion for sanctions. And I'm going to open this up. Let's see here. Motion for sanctions. Are you familiar what a motion for sanction is, Mr. Arthur?
I didn't hear you, Your Honor.
Are you aware of what a motion for sanction is?
Yes, Your Honor. I was going to ask the constable to ask you a question for me, please.
And what is that?
What is the end state that I have free will to litigate in this suit?
I'm sorry, I didn't understand the question. Can you repeat it?
As the plaintiff, do I have free will to conduct this hearing? And that's what it's a question of law, Your Honor.
Okay, but I don't know what the question is. Can you conduct this hearing how?
At free will to pursue the nuance litigation that was filed, but we're pleading the merits of the legal interferences, not the merits of the case.
Exactly. We're here on pretrial motions.
Yeah, I got some nuance for you right here.
So otherwise, I'll have to plead the fifth if I cannot have the free will to file my pleadings with the countersuit of the sanctions against the defendants.
Well, I mean, you can file whatever you'd like, but have you filed them?
Your Honor, I believe he's been labeled a vexatious litigator, and under the law, he's not allowed to file anything in any court.
And he's been formally labeled this as with other courts, or what is that?
Court. So under CPRC, Civil Practice for Remedies Code 11.101.
Go ahead.
To the judge, just for quick reference for her. And this. It's a court may own its own motion or a motion of any party. This one's got something. Oh, I'm sorry. Apologize for that. Court on its own motion, a motion of any party may enter an order prohibiting the person from filing pro se a new litigation in a court to which the order applies under this section without permission of the appropriate local administrative judge described in section 11.102. So the administrative judge knows about this. And we have an order from 2017 labeling him vexatious litigator. He's supposed to pay $7,500. I'll have that order for the judge in just a second.
Okay.
Under D, a pre-filing order entered under subsection A by a district court, which is a district court or statutory county court, applies to each court in a state. And so he doesn't have the right until he pays the $7,500. And I will. Would you want that order right now from the district court?
Yes, sir. I need to review all of these orders right now. And so, counsel, what is your end result in this hearing? To get this case dismissed or to file sanctions?
Well, Judge, I read this. I read this since I filed my sanctions, and so I believe I had to bring that to light before I brought up any sanctions to you. This may preclude me from asking for sanctions, but it certainly doesn't preclude you from holding Mr. Rackwitz in contempt, because he's been in contempt 5 times in district court, and here he is in contempt with you. Let me get you that order.
Okay. And what has district court found when they found him in contempt? What are the punishment? Is that the $7,500?
$7,500 is what he needs to pay for attorney's fees uh, uh, and costs in order for him to file and proceed with his suit in district court.
Okay.
And this is nothing more than his attempt to form shop from district court to here.
Mr.
Um,
Rackowitz, I'm sorry, Counsel, were you done?
I am. Now I'm gonna hand you this. Now I have an entire packet for the judge. I'm gonna leave. I don't think we want to scan all that in, but I'll leave it for you, Judge.
Okay,
And I had that same packet from Mr. Rackowitz. If he so chooses to take it, I can give it to him right now. But I'm gonna lay it right up at the bench.
Letty, if you could scan the orders in though, the most important papers, that I do need to see those.
Yes, Your Honor.
And then,
And I'm
go
handing
ahead.
Mr. Rackowitz everything I've handed you. And I'll put it on his bench.
All right, and Mr. Arthur, do you have anything to say about these motions that have, or let me rephrase that, about these sanctions that have been rendered already from previous and higher courts of Bexar County?
Through the constable, this is a filing that this case, the judge has jurisdiction, supersedes the counsel, opposing counsel, because now it is a federal investigation by the U.S. Postal Workers. And I also have something else that due to the litigation that was unknown to me, that the defendant's husband has passed away and the son, father has passed away. And at this time, I think it's inappropriate to be conducting any legal action for a grace period at a moratorium so that they may grieve without having, and that was the reason I filed my counterclaim against the legal counsel. And that's all I will say. Any further, I shall be silent.
Okay, all right, let me, counsel, wait till I get my exhibits.
So he commenced litigation to have a moratorium on litigation. Nice.
And then we'll go from there.
Your Honor, he gave me this card. I'm gonna scan it to you.
What was the card? Oh, was that something that he gave you for the judge? The card?
Yeah.
Yeah, can I say that to you? Yeah, of course.
Doesn't have all of it. What else?
Well, he's not too bright. You can either ask for continuance or the usual thing is what's called a stay. But he's the one who's bringing all this stuff. You can't you can't ask for a stay of your own litigation for no reason. For instance, you get a
And then counsel, this case in county court,
bankruptcy
is
fee.
it an exact replica of what's going on in this court?
Yes, Your Honor. I realize it's not a certified copy. I apologize for that. I should have gotten a certified copy. But that is the exact replica of what I've seen online and before. And that's I'm representing to you, that's a copy of the actual order.
But the merits of this case in county court are exactly the same merits of this case.
I've got to be, I can't tell you that, Judge. I don't understand any of his pleadings.
Okay.
Okay.
Okay, that
give
much
me
we
1
agree
minute,
on.
counsel. Hold on 1 minute.
What? Oh, yeah. Oh, okay.
He needs jail time. He's already got a $7,500 sanction that he doesn't have any money, so that doesn't mean anything, is my guess. He needs to spend some time in the gray bar.
Okay. Mr. Rakowitz, this case pending in 2017 with this order signed by John Mead. Let's see here.
Judge Stryker.
Yes, Judge, I'm sorry. Are you aware of this order, Mr. Arthur?
There is an order, Your Honor, that I was not even aware of. I didn't find out about it until recently when a deputy of the clerk presented to me that it was somewhere tucked away. I never received it.
Okay, but you're aware of it now.
I am aware of it now.
Okay, and has the $7,500 been posted?
I plead the fifth, Your Honor.
Okay. All right. So from county court, it's and counsel, I'm assuming this judgment is still valid, correct?
Your Honor, that case is still going and that judgment will be valid within that case as long as it's live.
Okay. And Mr. Arthur Rakowitz, is the case pending in county court that this order is referring to, is it based on the same merits of the case here in JP4?
Could you, I didn't hear that.
So the case in county court for the case that you have the order for the $7,500 security bond, the case against you and Barbara Pittman and Wayne Pittman in county court, is that case based on the same facts as this case in county court, in my court?
No, Your Honor.
And how are they different?
I plead the fifth, Your Honor.
Okay, since you're pleading the fifth, then I'm going to make my own determination because I'm giving you a chance to explain and you're not, and you have that right to plead the fifth. But at that point, I will make my decision based on that then.
It is not, Your Honor, due to.
Okay, Arthur,
Yes,
I'm
Your Honor.
going to stop you right now. I'm not playing your games. If I ask you a question and you choose to plead the fifth, then that's your answer. We're not going to go back and forth based on, well, if I don't answer, this is what's going to happen. You either going to answer and you're going to stick to your answer, or I'm going to make you stick to your answer. We're not going back and forth. You
That's all I
choose
need
to
to
plead
know.
the fifth, then you can plead the fifth. When you choose to answer the question, you can choose to answer the question. I'm going to ask you the question one last time, and I will take your answer at face value. Is the case pending from 2017 in county court that you have this order for sanctions based on the same facts of this case pending in JP4?
No, Your Honor.
All right. What is the difference in facts?
The 2017 in the district court, Your Honor, is to exit out of the court because there is a dismise. The late Mr. Pittman is no longer part of the suit, and I have a declaration that I was just found, and it's based on the sanctions that I filed against the Mohar law firm because we originally had a agreement and he's been sidestepping and avoiding me. And it's due to the comment that I made earlier that Mrs. Pittman and her son are in a state of grievance right now. And it's not appropriate to have myself. I want to be held harmless of any personal injury to the conscience of Mrs. Pittman and of the son, because I have the utmost respect for Mr. Pittman. For one, he's a veteran, and so am I. I was trying to legally withdraw Mr. Pittman as a veteran honorably so that there would be no legal whatsoever disgrace because of him being a veteran. To show my reverence is just as millions of other veterans that have fought for this country.
Oh, spare me. You want to drop a party? Fine, drop a party. It's the same facts.
The democracy.
All right.
And
So,
with
Mr.
that-
Arthur, give me 1 minute. Hold on. Counsel, he
Yes,
keeps
Your Honor.
bringing up this delay of the case due to your clients needing a moment to grieve.
No, Your
Of
Honor.
course, I have to ask you, are you in agreement to this continuance?
No, Your Honor, I don't believe we are.
Okay, so Mr. Arthur, I understand that you're wanting a continuance based on the respect aspect, but again, that's not a legal reason. So today we are going to proceed forward. Counsel is not wanting to delay this, probably for the same reasons you're saying. They want this over with and done with. So we're here now, and I have to determine if sanctions are valid enough or not. So give me 1 minute. Let me read the council's motion for sanction.
Number one, know what I'm saying? Number one, know what I'm saying? We are the Lord's all my crew. Number one, know what I'm saying? Number one, know what I'm saying? Number one, know what I'm saying? Number one. There is no schedule at Law Talk Nation. You can only pay, get a notification. If you're lucky, it's a spicy fornication. It's another day on Law Talk with Mike. We got pretrial on the
All right, and counsel, she's accumulated $4,000 in attorney fees.
Yes, Your Honor.
And counsel, talk to me about mediation.
Okay, we have tried to, or he came by our office and he asked to negotiate, not mediate. And I said, you know, I'm welcome to that idea. And, you know, let's discuss dates. And we didn't discuss dates that day. Mr. Rakowitz does not have an email. He doesn't have a phone. The only thing he has is a post office address. So if I send him dates that I'm available, by the time he answers via regular mail, I don't think I'd have those dates anymore. So he had motioned the court for mediation, and I am fine with the court ordering us to go to mediation. I'm okay with that. I'm not saying that we can't mediate. I've never turned down mediation. I can't set up and schedule a mediation with somebody via regular mail. It's just impossible. And I don't understand why he doesn't have a phone or email.
So, Mr. Arthur, are you in agreement to setting up mediation at the Bexar County Dispute Resolution Center?
Your Honor, I have tried. I have a document here.
That's not what I asked you. We're here now. Are you willing to go to mediation at the Bexar County Dispute Resolution Center? Yes or no?
Mr. Wilson will show up and hold on to his to the agreement. I would be happy to, but if he doesn't want to, there's no use in me, Your Honor.
Okay. So nobody said nobody wanted to. Counsel has literally just testified that he's willing to mediate. So let's stop with the opinions. Okay. We're here now. Both parties have already mentioned in open court that they're willing to mediate. Is that correct?
Yes, Your Honor. There's also something that you weren't aware of, that Mr. Wilson failed. Mr. Wilson, when I met in the office, are you familiar with the Robert's Rules, Your Honor? I even went and bought a book of Robert Rules because he presented that to me, and I wanted to make sure that I was in compliance. And I
For what?
Since I got dates in August, and on the second letter, the same way.
Robert's Rules is how you conduct a meeting. It's well known or whatever, but it's not controlling authority in the circumstance. What the hell is this attorney doing? Accepting his stupid premise.
And so I've done everything I could, Your Honor, to try
Okay.
to.
Mr. Arthur, do you have a point of contact?
We have Mr. Wilson knew that I don't have a phone, that I do things by correspondence. I've even corresponded with legislators, and that's my only means, Your Honor.
Okay, so I'm gonna tell you this, Mr. Rakowitz, because the court's done wasting time on this case and we need to either get it adjudicated or not. The Bear County Dispute Resolution Center is gonna pick a date. We will get with them. Letty, make sure you put notes on this. We will get with the Bear County Dispute Resolution Center. We will pick out a date and there is no negotiation. Everybody will meet on this date. And at that time, if nobody is met or nobody shows up or one party doesn't show up, then I will reevaluate the sanction motion and we will go at the full extent at that point.
I agree with you, Honor.
Is that understood on both sides?
Yes, Your
I
Honor.
have no problem with it, Your Honor.
All right. Since Arthur, we aren't going to do this snail mail back and forth because that runs into an issue. And again, if you choose to do that way of method, I can't stop you from it. That is your right. But that limits us of what we can do. So we will pick out the date. It is not negotiable. Unless the world is ending, you will appear at that date. Okay? And that goes for counsel as well. Counsel, if you can't physically appear, you need to send somebody.
I will.
All right. So I will set up a date for mediation. Depending on how mediation goes, I will then address the sanction issues.
Your Honor, may I ask something of the court?
Yes, sir.
There is, during this past week, the court probably is not aware, I had back in 2013, I was involved in a severe head trauma of a shooting in the face. And due to that, there may be a medical condition and I won't really know until I'm seeking medical attention. And the individuals that perform the surgery are not locally, they may be scattered. It's imperative because even swallowing water is beginning to be painful and it's becoming a detriment. And I hate even bringing it up because it's even more detrimental because I found flies in my refrigerator yesterday after leaving the Bear County Courthouse. But I don't have no choice. I need to keep the court informed, just like I have to keep the law enforcement informed.
Wait. Do I have this right? He has flies in his refrigerator? And that's relevant how?
But unlike everybody else in this room, they can go to McDonald's and eat whatever they want. My food intake to maintain myself is special.
Mr. Arthur, what does this have to do with mediation?
Well, I may have to have surgery,
Flies in the refrigerator and special food intake. Got it.
and I don't want to disrespect the court that, okay,
Too late.
this is my open window for surgery, and I would like to find out, Monday is the date that we have a schedule with this medical provider, and I'll know something more definite. But if I say yes right now, agree, and then the medical provider will have to may not be able to perform that, and I'm running out of straws, Your Honor.
Well, you and me both, Mr. Arthur, because I can only do so much for you. This case has been pending. Never once has this been brought up. And all of a sudden now, right when we're doing mediation, this has been brought up. You're going to the doctors on Monday. I expect to hear something by 5 o'clock Monday of a tentative date for surgery before I call the Dispute Resolution Center. If I don't hear anything from you Monday and I set the date, then I better get something from your direct doctor stating that you cannot be there on that date. Otherwise, you will be need to be appearing on that date.
I appreciate that, Your Honor, and I will, because my appointment's in the morning, and I will immediately come and bring it to your staff.
Okay, and then we will discuss it, and we will keep the counsel in the loop. And if the date is open, we will find a date to where it's before the surgery, so we don't have to wait for recovery time. We need to get this case moving.
Yes, Your Honor, I agree.
All right, we will
Your Honor.
reset it for mediation. Yes, counsel.
Do you need anything from my office concerning dates or scheduling or anything?
If you have anything, that would be great that you have open. I will definitely take that into consideration.
Can I send it to
along
your
with,
email?
yes, you can send it to my email
Thank you, Your Honor.
or the clerks, whichever email they give, she'll bring it to me either way.
Thank you, Your Honor. I will do that today when I get back to office.
All right. Thank you guys. Y'all have a great one.
Consideration for Wayne, you wouldn't give it.
Do not talk to him. Do not talk to him.
Mr. Wilson.
Ethan, take care of that.
Yes, Your Honor.
Thank you. Y'all have a good day.
All right. Let me get Gloria and Gary.
Well, there you have it. That guy's absolutely insufferable. He does the last ditch head injury argument at the end. I don't buy any of it, especially since he's been in prior litigation. I'm guessing his competency has been questioned all along. It's complete nonsense. It was a lot of fun. Thank you, Alyssa. As always, I don't know why the format was weird, but I'll take it. It was good times. I'll see y'all soon.